Well, just days after it began, an Ontario judge has declared a mistrial in the high-profile sexual assault case involving 5 former members of Canada's World Junior Hockey team. Jurors congregating in the London, Ontario courtroom this morning, only to be told they are being dismissed to make way for a new group. Lorne Honickman is a lawyer based in Toronto, well known to this program, joins us now. Lorne, great to see you. Welcome.
Yeah, nice to see you, Anthony.
So I want to stress, obviously, we can't get into the details of the specific case for legal reasons, nor even the circumstances which may or may not have led to the mistrial. But in terms of in general, what are the circumstances under which mistrials can occur? And is this quite common at all?
No, it isn't common, because it's important to remember that a mistrial is what's called a remedy of last resort. It's reserved for what you'll always hear judges say in the clearest of cases where there's no other remedy short of a mistrial that will adequately address what may be the problem or what has happened. So a mistrial is only declared when the order is necessary, and you'll always hear these words, Anthony, necessary to prevent a miscarriage of justice. So they are very rare. But they happen, and they happen as sometimes, as always, we see for a very good reason.
Okay, so it happened very early in this trial, in the first few days, in fact. Talk about the timing and how important that is.
Well, it's huge, because what happens, as you know, especially in this particular case, where it was estimated that this could go on for 8 weeks, and I can tell you, trial estimations are inherently flawed. Sometimes you'll always hear, oh, we're going to do a 2-week trial that turns into a 4-week, but even if it's a minimum of 8 weeks, that's a long trial. And you can just imagine if something happened halfway down the road. The fact of the matter is, all that happened in this case, there was a Crown opening, a witness had begun testimony, and that's when the issue arose. So that's good. That's a very good happening, if you will, that it happened early in the trial and it wasn't later on. The other thing to remember, of course, is they're picking a new jury. And so you say to yourself, this is a case that already has a high profile to it to begin with. And hopefully the prospective jurors that are being picked right now, and in fact today, hadn't heard very much about what had already taken place this week. So the fact that it's happening at a very early stage is a very good thing.
All right, you mentioned the next step in terms of choosing a jury. What happens from that point on, and how difficult is that process?
Well, you know, choosing a jury is always it's not a difficult process, but it is a very obviously important process. And what a judge will do, and what lawyers will do with prospective jurors, is to ask them all certain questions to make sure that they don't have what's called in law any type of bias. So each prospective juror, in this case, the judge is going to ask them, what have you heard about the case? How much have you read about the case? Can you put it out of your mind? Do you know anyone connected to the case? That's an important thing that you have to be able to ask somebody. And you know, you have to have it to sit on a jury. We have an incredible jury system in this country, but to sit on it, it's not an easy job, as you know. You're going to be there. You're going to hear lots of things. So each juror, prospective juror, is going to be asked those questions, and they may even be asked questions about, what do you think of hockey players, for example. And again, you just want to make sure that you get people who are sitting there who aren't biased, who don't have any preconceived notions. They're going to listen to the evidence and make those decisions. And while it seems like, wow, that's impossible, it happens all the time, and that's the great part of our jury system.
Okay. We know this case heavily focused on the concept and the question of consent. What exactly does that mean in law? And given that, and given the fact that a number of years has elapsed between the alleged incident and the trial, what does the Crown have to prove?
Well, it sounds like such an easy concept, Anthony. You say, well, did a person consent or not consent? But when it comes down to it, and what the law is, it's a very complex and complicated area. So The Crown has to prove beyond a reasonable doubt that there was no consent there with respect to any alleged sexual assault. And it's a matter of, at the end of the day, a matter of credibility, is considered in light of all the evidence. It's open to an accused, for example, to claim that based on a complainant's actions before and after, there's a reasonable doubt there. But on the other hand, the law is there to protect and say, well, look, you can consent at one point. You could be with somebody for, in a hypothetical, for 5 hours, and you may have consented to some activity for the first 4 hours and then changed your mind. So it's fluid. And then there's the issue, what's called in law about, and we have no idea, of course, we're talking hypothetically, no idea what the defense will be, but the defense can raise something like, well, I had an honest but mistaken belief. I believed that there was consent, and maybe I was wrong. And again, in order to prove that, we're back again, Anthony, into a very complex area. Self-induced intoxication will take away that defense. If somebody's reckless or willfully blind, or if somebody didn't take reasonable steps, and that's a very important concept in law. So that whole area, consent, was there consent? What did it mean? Could be front and center in this case. And everybody has to understand it's not just a simple, oh, okay. It is very complicated area, and it's something that the Crown is going to have to prove beyond a reasonable doubt that there was an absence of consent as defined in law.
Lorne Honickman, we always appreciate your insight. Thank you so much.
My pleasure, Anthony. Nice to see you.